those is directors and officers liability insurance. Now, publicly traded companies, companies whose securities are traded in the public market, almost all have D&O liability insurance. Not all privately owned companies do. In my view, they should. If you don't have this, as I said before, there are some principles here that are just generally applicable to companies in any marketplace, and pursuing directors and officers liability insurance is one of them. Another type of insurance that may apply is errors and omissions or professional liability insurance. A note regarding the term professional liability. Please don't let that lead you to think that this only applies to the traditional professions like medicine and law, engineering, things like that. That is not the case. Professional liability policy, in quotes, or more accurately termed errors and omissions liability insurance, is available for a very wide range of services, including a lot of services that are performed by manufacturers. So it is not even necessary that you be primarily a service provider in order to purchase this coverage. A lot of manufacturers sell services that are related to the products that they sell and manufacture. For example, we have clients that sell equipment, and they also sell contracts to service that equipment. The mistakes that they make in connection with that service may well be covered under errors and omissions insurance policies. And actually, clients that we have purchased that insurance in order to protect them against that risk. General liability insurance is another. I'm sure everyone within the sound of my voice this morning, their company purchases that. It is almost completely standard. Cyber liability, data breach coverage. I'm using a couple of terms because it's important to know here that cyber coverage is not as uniform as some of the other forms of coverage. It's still rapidly developing. There are a lot of different forms. So you want to find out as much as possible regarding what's available there in those coverages, and see what it is that you're really purchasing, whether you're buying the best available coverage or not. Things like cyber extortion, etc. So these are the broad types of coverage you're going to want to think about. Now, once you've thought about, maybe you've decided to purchase those coverages, or maybe you have those coverages, where do you go from there? Well, as I said before, you want to use your insurance broker as a resource. You want to think broadly about what it is you're buying. Are there any specific general categories you're not pursuing that you should be pursuing? Now that you're changing into perhaps a government contractor, if you had decided previously not to purchase E&O, should you revisit that decision? If you had decided previously not to purchase cyber coverage, should you revisit that decision? D&O, again, go back over those general categories. You should also consider asking for your, if you have an insurance broker who's fairly substantial in size, they may have people within their group, perhaps people that you haven't dealt with before, but that are under their umbrella, who have some real expertise dealing with government contractors. They may have either a specific group that's dedicated to that specific unit within their insurance brokerage, or they just may have a particular person who's got a lot of experience with placing insurance for government contractors. If so, you want to ask for the involvement of those folks if they're available to you. So you may be dealing with someone who's very good, who knows your business, who's giving you great service, but now you're doing something a little bit different. You want to make sure that they've got the help that they need, and that they're able to give you the good service to which you're entitled. And then once you get those people involved, and once you've made your big decisions about what types of insurance that you're going to pursue, then the next level is to start to think about, are you getting the best terms and conditions, the best definitions within those policies that are going to be important to you in dealing with the exposures that we just talked about a few moments ago. And the time to do this typically is as you approach renewal, before a claim arises. If you take control of this process. Have your broker reach out, secure better terms. As I mentioned before, some of these terms may be available just for asking. I've seen many instances where policyholders have improved their insurance program without spending more money just because they had a diligent broker who pursued some better terms. Sometimes they can be available at some cost. The cost might be modest and very much worth it. So the time to do that is before you have a problem. Once you drill down into the policies, a complete review, a complete analysis of all the different things that are going to matter to a government contractor is a little bit beyond the scope of this program, but I'm going to highlight a couple things that you definitely want to be focused on. And these are certain terms within the D&O and E&O policies that may have a very significant impact on what coverage is available to you. If you are named in one of the statutory claims that I mentioned earlier, so this would be KETAM, False Claims Act claims, Stark anti-kickback, government proceedings under HIPAA, seeking fines, investigations, etc. And of course, those HIPAA claims may also be the same facts, may become common law claims by individuals whose information is compromised. For example, negligence claims, breach of contract claims for people whose information has been wrongfully disclosed. So those types of claims are susceptible of coverage under D&O and E&O policies. And there are some important terms within those policies that are available to you that will increase the likelihood that you get covered. And the first one, sort of appropriately enough, is the definition of claim. D&O and E&O policies are both claims-made forms, and the starting point is whether something meets the definition of a claim. Almost every D&O and E&O policy form I've ever seen includes a written demand for monetary relief. That's sort of a starting point for almost any definition of a claim. So a written demand for monetary relief could be a letter from a lawyer that says his client has been injured because of something that you did, and the lawyer demands money from you. That's a written demand for monetary relief. It's going to be a claim under almost every form of D&O and E&O policy in existence. But there's a lot of other language that can be included in the definition of claim, isn't always included, can be, and it can be beneficial to government contractors. One of them is a demand for non-monetary relief or injunctive relief. The government tells you you've got to do something, you've got to take some step. That step might be expensive, or maybe you want to defend against the government's insistence that you take that step, and defending against that is expensive. Another is the cost of defending a criminal proceeding. Remember, these sorts of claims, False Claims Act claims, they have an overlap with criminal statutes, right? So a False Claim Act is a claim essentially for intentionally defrauding the government. If the government thinks you've done that, they may open a criminal proceeding. The cost of defending a criminal proceeding could also be included in the definition of a claim. Another one is administrative investigations. As I'm sure you're aware, there are lots of different government agencies that are entrusted with pursuing and investigating things that might be wrongful conduct. And again, dealing with those investigations effectively usually requires lawyers. Lawyers are expensive, and you want those things to be considered a claim under your E&O and D&O policies so that you can begin to access the benefit there of the contractual defense cost benefit as you need help in those situations. The next definition you want to think about is loss. Again, the basics would be an award of damages, compensation, judgments, things like that. Almost every definition of loss includes those things. Verdicts against you, civil verdicts against you are going to be loss and eligible for coverage under the policy. But there are broader definitions that include a lot of other things as well. And the relevance here should be obvious, right? You can get definitions of loss that include civil penalties, fines, Some of those may require that the conduct leading to the fines and penalties was not intentional or willful, but still, you can be fined in those situations, and those can be eligible for coverage if you've got this superior policy form. The broadest ones are going to cover a wider variety of things, liabilities that your company might face, right? And then the important thing to consider as well is defense costs. Of course, I'm sure everyone listening to me, their company is not going to be involved in doing intentionally wrongful things, defrauding the government, but you could be accused of that sort of thing. And the cost of vindicating your company, defending successfully against an accusation like that, could be very substantial. And you pay for insurance to try to transfer that risk to someone else. So by getting these superior definitions, better forms, you increase your likelihood that you're going to be defended, and that risk of those defense costs is not going to hurt your company. There are also a few exclusions that matter. We generally refer to these in the insurance business as the conduct exclusions. Again, these are found in both E&O and D&O policies, and the profit exclusion. The conduct exclusion is straightforward enough. It applies to deliberate, fraudulent, or criminal conduct. As you'd expect, your insurance company doesn't want to cover that sort of thing. However, you can get coverage for accusations of those types of conduct. And the way it's done is that within the exclusion is embedded what we call the final adjudication language. Not every form has this, but many do, and it's what you want. Basically, it says the exclusion only applies if there is a final adjudication or a judgment by a court that establishes that the insured actually committed the deliberate, fraudulent, or criminal conduct. So if you're vindicated, or if it's not intentional, that exclusion is not going to kick in, and you're going to be eligible for coverage. Similarly, with the profit exclusion, this is an exclusion that says the insurance company is not going to cover or reimburse you for illegal profits that your company was not entitled to. Again, not surprising. I don't think any company is going to expect that their insurance company is going to be willing to pay for that sort of thing. But in many instances, they are willing to include the final adjudication language in that exclusion. And therefore, they're going to pay you, they're going to cover you for accusations that you got unlawful or illegal profits. And that if you successfully defend them or settle, you may be eligible for coverage under your policy. So you can see, I think it's fairly evident, these are important definitions. I should say this, the final adjudication language, the fairly broad definitions of loss and claim are widely available in the marketplace. There are a lot of forms that are commonly sold. I would say more forms that are out there than have them than don't. But there are still insurers out there that are selling narrower forms. You want to push for the good stuff. That's what you have a broker for. Finally, you want to think about specialty products. As I said, there is some degree of specialization in the marketplace. That's been increasing over time. There are some very specific things that you can look for. One of them is if you're in the healthcare industry, for sure, there's been an evolution of more specific forms that have been developed that are more customized to that industry, to the types of claims, the types of situations that can arise, that are intended, for those industries. Another thing to think about is, as I mentioned before, there's DBA insurance, which is just a specialized product that's only going to apply to federal contractors in the situations I mentioned before. Another thing is that some insurance companies, some of the larger insurers, have developed what I would call specialty practice groups or specialty offerings, where they're going to, for want of a better term, have a marketing offering that's directed to federal contractors, where they bring together some underwriters and the forms that are more familiar with that marketplace, and to some degree maybe customized for federal contractors. Chubb is an example of that. They have, if you go on their website, you will find that they have made an effort to bring together all the different coverages, the different offerings that they have that are customized for federal contractors. So there may be some advantage in seeking to deal with an insurer that has this type of specialization within their marketing strategy, because again, they're trying to put their best foot forward and bring people to deal with you that have a little bit more experience. And as well, as I mentioned before, your insurance broker, particularly your larger insurance brokers, Willis, Marsh, etc. Some of these brokerages may have highly specialized people within their group that you haven't dealt with in the past. You've been dealing with their private market people, and you want to see if you can get their assistance because you're moving into a new marketplace. The general rule is don't ask, don't get, right? So please reach out to your broker, use them as a resource, ask for their best and most specialized people so that you get the best help. And then finally, of course, so your outside counsel. Make sure you're dealing with experienced insurance counsel who really knows what to do and how to help you and how to make sure that you're protected. So with that, that's the end of the insurance presentation. I'm going to turn it over for the next segment.